Oh, this is probably going to be the most boring video you'll watch today. But if you have never filed a trademark before, you must watch this video to discover what trademark registration process actually looks like when you're not cutting corners. So let's do this. There's a lot of steps, a lot of processes, and I'll walk you through them all in this video. Um, as a summary, really, this is the very um, simple bullet point form of what the trademark registration process is. So first is you need to figure out what you're going to trademark and where. Then you need to figure out what goods and services your trademark is going to cover. Then you need to find out whether your brand is even trademarkable. And we split that into two parts. One is we look at absolute grounds for rejection, and second, we look at other previously filed or registered trademarks. Then you need to get a registrability assessment that's written in plain English, and that's more than just pages and pages of other trademarks that are similar, but that actually contains um, a conclusion as to whether or not your trademark is likely to go through. Then you need to draft and file your trademark application. Then you need to take care of the follow up with the trademarks office as they examine your application. Then, assuming your trademark gets approved, you need to survive the opposition stage. And after your trademark gets allowed, assuming it gets allowed, then you need to take care of all the post allowance paperwork, get the registration certificate, and for some of you, you will want to do the weekly monitoring of what others are filing after to make sure that nobody gets to trademark a brand that's too similar to yours, and the trademarks office might miss that. And last point is after your trademark registers, you need to take care of mandatory maintenance filings and renewals. So let's go through each of these step by step, um, one by one. Yeah. So what can you file and where? So there's different types of trademarks. Um, I'm not going to talk about the unconventional trademarks like smells or just colors or sounds, or movements. Uh, these are kind of the outliers. I'm going to talk about the ones that are the most popular ones. So they have 9 possibilities here. One is you can trademark your business name. Some examples here: Google, Trademark Factory, or Kiss as a band. Um, Second is personal name or pseudonym. We trademark the brand for Dan Locke. There's also Beyonce as a trademark. Usually, it wouldn't be for common names. So you have to have some recognition under that brand for your personal name to be trademarkable. Then the third one is names of products. If you have physical products, then it's something that can be trademarked, like iPhone, Civic, or Big Mac. Names of services: iTunes, Prime Video, Oscar. Right, Oscar. The service there is entertainment services. Right, so they've trademarked the word Oscar for it, so that others can't hold their Oscar ceremonies. Logos. Now, there's 3 main types of logos. One is icons, when you just see an image, right? It could be a swoosh for Nike, or the icon for Facebook or Mercedes. And the second type of a logo is when you have your name written in a fancy font, like Coca-Cola, of course, that's famous, Disney or Canon. And the third type of logos is a combination, when you have the name and the icon together, Adidas, Starbucks, or Toyota. The next one is taglines or slogans. Um, the examples here: I'm loving it, just do it, or let's get ready to rumble. Right? All of these are phrases that represent something. And you can have combined marks when you have several separately trademarkable elements that are put together. So Apple CarPlay is a good example. Apple has a trademark on Apple by itself and our CarPlay by itself. And they also have a combined trademark on both Apple CarPlay. Right. The other one is Nike with the swoosh together, blended trademark. And this one is Toyota Let's Go Places. So it has the name, the icon, and the tagline all in one. So these are combined marks. So when you have all this, you need to figure out where what you want to trademark first, right? Which of these are more important to you? And really, the rule of thumb there is you always want to start with a word mark because logos change, names usually don't. And basically list all the brand elements you got and think about it from the perspective of what's going to hurt the most if you were to lose it, right? That's probably going to be your top one priority and just go down on that list from there. The next thing to think about is that trademarks are done on a per country basis. There's no such thing as a international global trademark. So you need to figure out where you want to file all this, whether it's US, Canada, EU, which is like 27 countries of EU that you can file a single trademark and get your brand protected in all 27, UK, Australia, or somewhere else. Like these five are the ones that we file the most frequently in. Now, once you know what you want to trademark and where, next thing is figure out what goods and services your trademark is going to cover. Trademarks don't give you a monopoly over your brand in vacuum for everything, right? It's not that you came up with an amazing name and now nobody can use it ever, right? Which is why you can trademark dictionary words like Apple, right? So Apple getting their brand trademarked doesn't mean that nobody can use the word Apple anymore. Because the way trademarks work is that when you get your trademark filed and registered, it will be creating a monopoly in association with a specific short list or limited list, doesn't need to be short necessarily, but limited list of products and services that you want to be recognized under. So here, you want to think about it as a matrix of 2 by 2 in terms of how you are going to put together your list of goods and services, right? First of all, you look at let's go through columns, right? So the left column here is physical products and downloadables. So if you have physical stuff that you sell under your brand, or you sell something that people can download, like files or something, then it will go in the left column. And if you sell services or are planning to sell services, then it's going to go in the right column. And here at the top, you're going to list the things that people can already buy from you under this brand in that country where you want to trademark it. And everything else, like if you are only planning to release or planning to start selling your services or products in that jurisdiction, then it will go to intent to use category. So having that clarity, mental clarity as to what you're trademarking for what goods and products is, well, good products and services, it will make it much easier for you to get your brand trademarked. Now, important thing here is that this is not your marketing piece, right? The trademarks office doesn't care how good you are, how revolutionary your services or products are, how they're helping the world become a better place. Like, it might all be true, but they don't care. So this is the place where you need to be super boring and just say, hey, if you're selling accounting services, it's accounting services, right? Doesn't matter how revolutionary, how convenient, how everyone's raving about them, how many 5-star Google reviews you got. Nobody cares. Just write accounting services and we're good to go. Now, once you have the brand, the country, and goods and services, then we can evaluate, or you can evaluate, whether the brand is even trademarkable. And you do that, as I mentioned in the intro, in two parts. One is the absolute grounds. So are there absolute grounds that can't prevent your brand from being trademarked? And here I've collected a list of 23. There's probably more, but these are just the ones that came to mind as I went through some of the office actions we saw recently. So you got descriptive marks, you got generic marks, you got deceptive marks, deceptively misdescriptive marks, primarily geographically descriptive, primarily geographically deceptively misdescriptive, primarily merely a surname. So again, if your last name is, I don't know, Smith, might be difficult to just trademark that unless, again, there's some recognition. If your trademark is ornamental, so if you just came up with a cute picture, cute meme, and it doesn't stand to separate your products and services from similar products and services if everyone else is just good for the image as it stands, might be rejected. Immoral, obscene, or scandalous marks can be problematic in most countries. U.S. is a bit more open to this right now, whether it's a government symbol, name, portrait, signature of a living individual, whether it's functional, whether it falsely suggests a connection with some other business, whether the mark is clearly descriptive in another language. So that's another one, right? So you can't just pick up a foreign word that stands for what you do. I don't know, something in French or in Spanish, and say, hey, this is our trademark. It doesn't mean anything in English, so we should be able to get this. No, that's not how it works. Whether it depicts a prohibited sign, whether it's a title of a single work. Now, in US, for example, you can't trademark a title of a single book. You can trademark a title of a series of books or series of movies, but not a single one. Whether it's not inherently distinctive, whether it's false designation of origin, whether it's matter protected by international treaty, whether it conflicts with plant variety denominations, whether it uses protected geographical indications, whether it uses Olympic symbols, or whether it's a non-distinctive trade dress. So all of these can be the absolute grounds for why your trademark can be rejected. So be careful. That's really what is in our checklist when we do the trademark search, to make sure that you don't end up filing for trademarks that won't go through. That's how we got the 99.3% rate of success, because again, we have these checklists that we go through religiously to make sure that you don't end up filing for something that's going to be rejected months down the road. You go through trademark search, and trademark search is really where a lot of corner cutting happens here in the absolute grounds, because if you just use the free trademark search databases, all they do is they check whether your brand is identical to something that's already there. They don't even look at absolute grounds, because that requires expertise, and the technology is not there yet. And even if there was, it's just not what the goal of those free trademark searches is. Their goal is to get your money to file your trademark, whether or not it's registrable. Now, so going to the actual search, there's a lot of other things that happen here other than you just picking your brand, typing it into some database, clicking search, and it's spitting out whether or not they think it's registrable. Because, like I said, you start with exact mark, yes, but then you look at exact marks for the chosen classes, right? Remember, we did the goods and services, so you want to look for that combination. Then you look at exact mark for specific goods and services. Then you look at exact mark for related classes. Then you look, if you have several words in your brand, then you break it down into words and you search each of them individually for chosen classes, for specific goods, for related classes, right? So if you have a tagline or a name with 3 words in there, then you just do it for each of these, right? Then if your trademark consists of words in a foreign language, you repeat these steps using translations. You translate that into English. For Canada, you would do this. If you have English, you translate it into French. And if you have your brand in French, you translate that into English. For US, we recommend doing this with Spanish. Then, when all of this is done, you do the same thing for synonyms. So, because again, you don't want to miss something that can prevent your brand from getting trademarked. Then you look for variations and misspellings and replaced letters. So, Microsoft, if you were to file with replacing all I's with number ones and O's with zeros, it would still be rejected. So you want to make sure that you take care of that. And then finally, you say your brand out loud. Does it sound like something other than what you see, right? It's a sound alike. And if yes, then you would run all these steps for what it actually sounds like. So, there are lots of words that sound like something else. Like meat with two E's or meat as EA, right? That's a good example. So you would change and you would and you would do these searches for both. Once you've done all of this, then you want to have some sort of closure where, based on the findings for absolute grounds and the trademark search, you can actually tell whether each trademark is likely to be approved by the trademarks office. And if you're not getting this from the company that's doing your trademarks, you're not doing yourself a favor, because we've seen situations where companies would send you 300 pages worth of printout of, hey, we've done your trademark search, here are trademarks that are somewhat similar. And I've been in this business I've been running Trademark Factory for over 11 years. I've been in the intellectual property space for almost 30 years. So I look at those 300 pages and I can't tell you right away whether or not the brand is trademarkable or not. So this is the danger of just running a search and relying on your ability to make a decision as to whether the brand is trademarkable. So assuming you've got that, and assuming that the outcome of absolute grounds and trademark search is positive, your brand is trademarkable, then you go to the next step, which is drafting and filing your trademark application. Here's what goes into your trademark application. Owner and owner details, then final version of the trademark, final list of goods and services broken down into classes, which is categories. There's 45 categories that they've divided all possible products and services into. So we've got 34 classes of products and then 11 classes of services. So you got that final list. In the US, if you have use for each class of goods and services, you need to provide evidence. Then you draft the application, then you pay the government filing fees. Which, by the way, this is something that you always have to pay, right? There's no such thing as a free trademark. There's always going to be a cost, and historically, those costs have only gone up. There's a hike happening as we speak. Again, I don't want to time this video, but like I said, the sooner you file, the less you're probably going to pay in government fees. And once this is done, you want to file your trademark application with licensed attorney or trademark agent. In US, you do that with licensed attorneys. In Canada, you do it with trademark agents. And there's many benefits to doing this through someone who knows what they're doing, as opposed to doing it yourself. The main benefit is that when your trademark gets rejected, and in 2/3 of the cases it will, you need someone who can actually understand the reasons and who knows how to deal with them. So strong recommendation to do this correctly the first time around, because problem is not that, hey, let's file some shitty application and then we'll have someone fix it. Oftentimes, you can't fix a poorly done trademark application. And the biggest problem is that you won't know if your application is any good until the trademarks office looks at that and happens in about 9 months in US, about 3 years in Canada. So you're sitting there with no way of knowing whether the trademark you filed is any good. And one of the common misconceptions is, hey, if I fill out the form and it goes through and they take my money for the government fees, I'm all set. Not quite. So file it with a licensed attorney or trademark agent. And after you file your trademark application, we have the examination stage. And this is, well, first, like I said, you wait, and then one of the two things are going to happen. Your trademark may get approved, happens in about a third of the cases. And if it gets approved, we send notification to our clients saying, hey, congratulations, your trademark got approved. And if it's not approved, then what they'll do is they'll issue what's called an office action. And these are kind of a short list of not really short, but it's a list of trademark of office actions that you can get, right? Obviously, it's closely related to the absolute grounds and the trademark search, right? So you can have office action alleging all this different things: likelihood of confusion, descriptiveness, genericness, deceptiveness, formality, geographically descriptiveness, blah, 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 all of this, right? All of this. Misleading health claims, improper use of collective and certification marks, contrary to law, non-ownership, non-use, like all sorts of different things. Mark is not used in like all of these different ones, and there's probably more, like I said. So if any of those happen, if any of those are issued, then really we need to figure out as to whether this is fixable, right? Can the application be amended to satisfy the examiner? Is there something that can be fixed? If you can't amend, then can you argue with the examiner and say, hey, you got it all wrong? And this is usually the second line of defense, because ideally you just want to give the examiner what they want and get your brand trademark. If not, you have to argue, and arguments can span pages and pages and pages of paperwork, legal paperwork. Now, if neither amendment or argument will satisfy the examiner, another thing we can look at is whether, like, for example, if the problem is that there's another trademark that someone else has that's cited against you, then the question is, maybe you can cancel that other mark. And if none of that work, maybe you can get coexistence agreement with the owner of a prior mark, right? So you try all this, and assuming that as a result of all this back and forth, your trademark gets approved. Again, we approve approval to the client, and if not, you just keep going over and over and over again. And if at the end of all of this back and forth, we get a final refusal, then we report the refusal to the client. And if you got our package that comes with 100% money back guarantee, which is by far Trademark Factory's most popular package, this is really the reason a lot of entrepreneurs come to us. Then here's where you get your 100% refund. Then, assuming, again, let's go back on the positive vibe. So let's say your trademark gets approved. Then it opens up a short period of oppositions. It's called opposition period. So during this period, it's 1 month in US, 2 months in Canada, 3 months in EU. You look at the few things. Well, was the trademark opposed? It happens very rarely, about 1% of the cases, right? So 99% of the cases, you don't need to worry about this. We call it an atomic bomb that almost never goes off, right? If it does get opposed, then, well, if it does not get opposed, again, we would tell the client, hey, congrats, your trademark survived opposition period. If it did get opposed, we tell the client, hey, we got a problem. And then you prepare a response to opposition. Then there's discovery and evidence stage. It's almost like a litigation, a court case, but it's not done in front of a judge in a courtroom. It's done in front of the trademarks tribunal, right? It's called TTAB in the US, and I mean, every country has their own names, but again, this is almost like a litigation within the trademarks office system. Maybe you can negotiate with the opposer. That's always a possibility. And again, after all is said and done, report the results to the client. Then, assuming your trademark survived the opposition period, which really there's two ways to do that. Nobody opposed your mark, right? All good, easy. Or somebody did oppose your mark, but they didn't win, right? So you got your trademark allowed, right? This is when we tell the client, hey, congratulations, your trademark got allowed. So in the US only, if your trademark was filed as intent to use, right? So before you actually had evidence that your trademark was um, already that you're already selling products or services under your brand, right? You can file the statement of use showing that, hey, now we are selling. If you still don't have use, then you can request an extension of time from the trademarks office, and you can do up to 5 requests. Each will give you 6 months. There's a small government fee attached to that, but you know, you've gotten to that point. If you still genuinely intend to start selling your brand, selling your products or services under your brand, that's how you do it. Or sometimes you may want to, like, for example, you file your trademark for in 3 classes and you have use in one and still don't have use in the other 2. You may want to divide your application and file statement of use for goods and services that are in use, and extension of time for goods and services that are not yet in use. So you can do that. And then so you pay post allowance government fees if necessary. Some countries have them, some countries don't. And then you get your original trademark registration certificate. So now the fashion, the trend is that the trademarks offices won't even send you the paper certificate; they just send you the PDF. And so what we do for our clients is we request a proper original trademark registration certificate on paper. We put it in a frame, a custom frame that we're ordering, and we put that certificate in that frame. We put that frame in a blue shiny envelope because I know how important that moment is, right? It's much more important, much more significant than us sending you an email saying, hey, congrats, here's your PDF. We want you to have something tangible, something that you can be really proud of, because it's a milestone that's very important for your business. So yeah, so we frame and mail that registration certificate to you. The next thing is the monitoring. We always want to offer this to our clients, as to whether you want a weekly trademark watch or trademark monitoring of third-party trademark applications, right? Something. Remember, I mentioned the opposition period. This is how everyone else finds out that, hey, there's a trademark that was filed by someone that's too close that we have a problem with, right? So this is how you find out, because you have someone monitoring the newly filed trademark applications so that you can oppose them when time comes. So this is something that all big businesses do. This is something that some small businesses do. So another thing to consider. Now, renewals. This is interesting. With trademarks, there's no such thing as annual maintenance fees, right? You do it. You don't need to do it every year. The renewals are every 10 years. Plus, in the US, there's an additional single mandatory maintenance filing between the 5th and 6th anniversary of your trademark registration. So once you do that, you're good. Now, this is really all the entire process. So let me go back to the intro once again for a second. So all of this is how you do it without cutting corners. If someone is not doing any of these things for you, they are cutting corners. Thing is, the trademarking process is the same, whether you do it with Trademark Factory or you do it with someone. Well, the one thing that's kind of extra that doesn't change the result of your trademark registration is the framing, and putting your trademark registration in a frame. But everything else, every single item on this list, on this boring list that I went through with you, something that needs to be done. If any of those are not being taken care of, they're cutting corners, and that's why the industry average success rate of file trademark applications is 51.2%, whereas Trademark Factory is 99.3. Here's where the difference comes from, right? Because we don't cut corners. We know that it's a difficult process, and we know that there are lots of steps that need to be taken to ensure that your brand gets registered. So if you want to file your trademark, if you want to get it registered without cutting corners, I would strongly recommend that you go with Trademark Factory. So let me walk you through what you can do with Trademark Factory. So there's two ways that you can get started based on your comfort of finding out that, hey, you have a brand and we tell you there's a problem with it. It might not go through. So if we tell you, hey, your brand is problematic, and you're like, well, that's the only one I got. That's the only one I wanted to go for. I have no replacement. I don't want to look for a replacement. I just want to stop right there and not do anything. Then I suggest you start with the single search. Basically, when we do this assessment, um, we do the absolute grounds analysis. We do the trademark search, all of those things that I told you about for one trademark. And we provide you with the registrability assessment. And if it's good to go, then you can upgrade to filing. Or if it's not good, then it stops right there. It only costs you $199, right? The other option is, so when you upgrade, it's $796. So it takes you to the total of $995, right? The other way to do this is to start with what we call unlimited search plus the filing with attorney. It's the same $995 as the bundle, but this gives you unlimited search. So instead of the first option where you only get one kick at the can, you pay $995, and if your first choice is problematic, then you come up with a second, third, fifth, 29th, until you come up with a brand that you love and that we tell you is trademarkable, right? So that's the difference. It's the same price, right? We don't want to incentivize you one way or the other. We don't want you to feel like we're pressuring you. So if you're like, hey, I want a trademark, I want to own my brand, and if my first choice is problematic, I'll come up with something else. Then go with what we call it a rec pack, right? So unlimited search with filing with attorney. And after we've done the search for you, and assuming you move forward, you can upgrade what we call office action insurance. So by default, there's none, right? No de-risking. You pay nothing, but if there is an office action, you pay as you go, right? Depending on complexity, depending on how easy it is for us to deal with that, things like that. And so there's unlimited responses to minor office actions you can get for $400. Basically everything except for issues of descriptiveness, genericness, and likelihood of confusion is included, no matter how many, right? So for $400, you cap your expenses on minor stuff, or you can go with unlimited responses to all office actions. So that's $1,000 total. So that brings it to $1,995. And so if there's any office action, including the hard ones, the genericness, descriptiveness, or likelihood of confusion, that covers you for $2,000. And finally, like I said, the most popular package is $2,500. So at the time of this, right? So we may raise our prices in 2025. It probably will, but as I'm recording this video, that's the numbers. So don't take me up on these if and when we do increase the price. So, but for now, again, the plan is that for $1,500, you get all of this plus the money back guarantee, 100% money back guarantee. So if we tell you your trademark is good, we file it, the trademarks office finds problems with it, we fight for it, and we lose, your trademark gets a final rejection, you get your entire $2,500 back. So that's why a lot of business owners come to us for, because nobody offers trademark registration services with a guaranteed result for a guaranteed budget, and we do. That's how it works. I hope this video was helpful. Again, whether you do it with us or not is on you, right? Depends on how important the brand is for you, but know that the trademark registration process is the same no matter who you do it with. It's just the question of, are they going to cut corners for you or not? So if you don't want your corners cut, go to trademarkfactory.com, request your free call with one of our strategy advisors, and they'll be more than happy to help you get started on this path. And I'll see you in the next video.